Hello, Dr. Nidhi. Dr. Nidhi Pathak, am I audible to you?
Hello, am I audible?
Yes, ma'am, you are audible.
Okay. Good morning to one and all present here. I, Nidhi Pathak, Associate Professor, IIMT University Meerut, welcome all on the behalf of IIMT University. Today, we are going to start 7 days workshop on the topic Future Perspectives of Intellectual Property Rights. Artistic fields. The most common IPRs include patent, copyrights, marks, and trade secrets. IPR is protected in law by, for example, patent, copyright, and trademarks, which enable people to learn, recognize, or beneficial benefits from what they invent or create. By striking the right balance between the interest of innovators and the wider public interest, the IP system aims to foster an environment in which creativity and innovation can flourish. Now, for the welcome note, may I request our respected Dean Sir, Professor KD Sharma Sir. Sir, may I request you, sir?
Good morning to all of you. It's a nice pleasure that the School of Arts and Merit is going to start this workshop, 7 days workshop. Positively, when we talk about intellectual property rights, so number of things we can easily assimilate all these things. So it is quite possible for us to understand the basic structures of IPR. For your kind information, I would like to share my experience to learn this intellectual property rights as well as its contents. there is one important content, copyright, plagiarism. So it is very important for every individual to learn and understand the theory as well as the basic concept of IPR. And I hope that I will not take much more time and invite our respective speakers to take care of all this. Thank you very much.
Thank you so much, sir. So for the first session, our keynote speaker of the day is Dr. Arjun Solanki, sir. I would like to share some words about Professor Arjun Solanki, sir. Dr. Arjun Solanki, Professor of Economics at IIMT University, Meerut, is an excellent academician with more than 18 years of rich experience in graduate, postgraduate teaching and research in the area of economics, and a double postgraduate in economics and management. He is a gold medalist in MA Economics, the first rank holder in MPhil, PhD in Economics, and also UP SLAT qualified. His national and international publications include book on engineering and managerial economics and research papers on significant truths and challenges in the economic world. His research deals with liberalism and technological changes in the context of Indian manufacturing and the impact of liberalization policy on Indian agriculture. He has successfully worked as a certified resource person for the Securities and Exchange Board of India, SEBI, for many years and conducted more than 200 workshops on financial awareness. Currently, he is associated with Indian Institute of Corporate Affairs for the same cause. During the course of his career, he has been in various administrative positions where he developed the institutional framework and was at the core of various conferences, seminars, and FDPs while leading the team. He has been accepted many awards for his remarkable services. He has been guiding thousands of students with his extensive knowledge and shares best of his experience among students to make them successful. Presently, he is serving as a professor of economics in the School of Arts and Humanities, IIMT University, Meerut, UP. And now I would like to invite Professor Arjun sir.
Thank you, madam.
Welcome,
Am
sir.
I audible?
Yes,
Am
sir,
I
you are
audible, ma'am?
Yes, sir, you are audible.
Okay, thank you, ma'am. Good afternoon, all of you. This session is, as madam has informed all the students about IPR, we are going to have a session on intellectual property rights. So this workshop is going to be continued for 7 more days. So in this session, I just want to introduce you with the what actually intellectual property right is, what we mean about intellectual, what we mean by property, what we mean by rights. You see, students, it is in this coming times, intellectual property rights is a hot cake. I mean to say is, intellectual property rights earlier, when so much development was not done, we are not aware of our rights. Like the rights, as I said, when we are not aware, we we are not going to protect it. If we are not knowing our rights, we are not going to protect it. So it is very important that we should know what are our rights, what it is related to, and what, if it is come to intellectual property, then what we mean by intellectual property. So before I start, about the session, I just want to give you a brief idea about the property, which we all are knowing what property means. In general sense, property means whenever we talk about property, we mean property like land, like anything which belongs to us is our property. So intellectual property relates to original ideas, results that emanate from research, and generally it covers some kind of critical in business informations. Intellectual property refers to that set of properties that emanates from human creative labor, because intellectual means creation of mind, and property, real property, means like pen, like laptop, like land, like your house, your car, is something different. So we have to differentiate between the real property and the intellectual property. So when we mention intellectual property, we are specifically trying to define intellectual property as that is distinct from real property. As I mentioned, like land is different from an idea. A land belongs to you or me is my property. Likewise, an idea created by you, an idea created by me, is also a kind of property. The difference is only the physical tangibility. One is available, one is observable, another is only observable, not tangible. So we will discuss what are the properties and things of intellectual property means to us. When we come to intellectual property, we do have certain issues to understanding the outer limits or the boundaries or the private space of intellectual property. See, when we are talking about land, laptop, we have limits, we have boundaries, we have a private space. But when it comes to intellectual property, it has no space, no boundaries. An idea can go from here and there. It can be used by anyone. If it is not protected, what I mean to say is, if you are not going to protect your idea by so many legal rights provided by the intellectual property rights, which we are going to discuss in our coming session, we are not able to protect it. And in that case, anyone can steal your idea and can be misused. So intellectual property specifically refers to things that emanate from human creative labor. Intellectual property manifests itself in various forms. For instance, if you look at invention, and invention is an intellectual property which can be protected by a patent, which is an intellectual property right. A literary work like a book, or the work that is written or expressed in words, could be an intellectual property which can be protected by intellectual property rights, that is copyright. See, here I use two intellectual properties. One is patent and another is copyright. Before going into detail, I just want to introduce you with these two terms, that is patent and copyright. Patents are granted to the right holder on the basis of their inventions, and it is not that you have done something new only the patent will be provided. If you have done some improvement also, that can also be registered in Indian patent law. So students, it is very important and required that we should protect our original ideas, original research, so that it will be protected and can be used for further research and development. Now, likewise, patent, I said, we have literary work also, like music, like movies, like writings. For example, if you have written a book, that should also be protected. But copyright is very complex. We will discuss it later in detail. So there is a distinction between intellectual property or the rights of property that manifest in certain creations made by human beings and the right that protects these manifestations. Now, intellectual property and intellectual property rights. What is the difference between intellectual property and intellectual property rights? Intellectual property and intellectual property rights, that is sometimes used interchangeably also, and I think there is no problem in using it interchangeably. We talk about intellectual property, we also want to cover or encompass the corresponding rights also. So a right refers to a right refers to a legal entitlement, something which you are entitled to get legally. For example, there are so many kinds of rights you have. Right of privacy is one of the right. It is something that can be justified, that can be recognized, and can be protected, the violation of which is deemed as unlawful, and the violation of which leaves the person whose rights is violated with a remedy. For example, you have your house. So legally you have the right that you can allow or disallow anyone to enter in that house. Means your property is protected by law. Likewise, in terms of intellectual property also, if you have a right, you can allow and disallow anyone by giving them or granting them the limited patent, license, permission for a limited point of time, limited period, and in return you may get money or any kind of advances. Now, rights can be used in two broad senses. It could be used in the sense of a liberty, your ability of freedom to do something. It could also be used in the sense of a license, your right to do something because somebody has given a consent or somebody has been allowed to do certain things. So ultimately, what rights means? So before going further, we should know what rights means. I just give you a brief introduction what right means, but what rights may express itself inherently in a human being, like what we say about human rights, your right to vote, your right to privacy. These are things which are inherent in a human being. Means once you become getting an age of 18 years, you have a right to vote. It is inherent. Nobody is going to you need not require any permission. It is inherent. Like there are also rights that manifest in things beyond the human being. For example, property. Property, you have seen that some few people have large houses, large land inherited by their fathers, forefathers. So that is again an inherent thing. Means that is passed on to you or me by my father or from my grandfather. That is inherited. And we also have rights that express on things because human beings can possess, own, transfer things, and we can transfer our property whom we like. We can grant permission to use it also. So in that sense, rights are created by the law. In fact, you need a legal recognition for something to be regarded as a right. Rights can be of general nature, which are shared by a people, like the right of protection. A citizen expects from the government is a general right which every citizen can claim, and every citizen will get, whereas there are certain rights that could be operated or that could be exercised in an exclusive manner. Now, when rights offer you exclusivity means that no one else except you has the right to use that particular property without your permission. So it means that you have a right to stop people from doing certain acts. For instance, if you own a property or a book, you have a right to exclude people. So exclusive rights are rights which confer the ability on a person to stop others from doing things without his consent. So if you have a right of anything which you possesses, no one else is going to use it without your consent and or permission. If anyone is using it without your permission, it means your rights are in technical in terms of legality, we can say that your property law as infringement of your right. That trespass means somebody has come into your property or using your property without your permission. It is also called as trespass. Now, in connection with intellectual property, we are talking about rights that emanate from the intellectual property which are capable of being protected. For instance, if there is an artistic work in the form of a book, then the creator of the book or the person who owns the book or who created the book could stop other people from using that book, from making copies of that book, from disseminating information from the book by different ways, because he has an exclusive right over it. In this case, we call that right of copyright. Now, what we mean by property in intellectual property right? I have just explained you what real property or what we mean by property. Now, we discuss about what this property means in intellectual property right. So in starting also, I have given you a short introduction of intellectual property, that it is intangible. You can observe it, but you cannot touch it, you cannot feel it. So property is a form of regulation, and when it comes to intellectual property, we are talking about a form of regulation of creations that come out of the mind, human mind. Property can be either public property or private property. These are broad classifications of property. Means a public property, for instance, means something which is held in common, what we call the commons. Means from public property, no one is disallowed to use it. It is free to everyone. Some are using it more, some are using it less, but if anybody is using it more, they are not going to pay more. But a private property is something which a person holds for himself individually, and it solely belongs to you or yourself, your house, your car, your pen, a pencil, etc. Now, intellectual property does not exist in time and space like real property, because intellectual property deals with creations of mind, like an invention or an idea of an expression. We need to have some form of by which we can ascertain the limits of property. When a person comes up with an invention, the invention could be improvement in an internal, like an engine. Someone can make a claim that he has done some improvement in a engine. That's so in that case, that can also be a kind of intellectual property. But it is again very important that whatever you have done should be registered, because without registering, maybe your original work someone other has given an application and registered it, it does not belongs to you if he has registered it on his name. So it is very important that when we when we are going to file our patent application, we give each and every detail in minutely, we explain everything that what we have done, and it is up to the patent office that they are going to scrutinize it, and then on the basis of it they give you or deny it the patent. Now, like intellectual property is not readily discernible, because the rights do not manifest itself in time and space in a tangible or an intangible form. We find it difficult to settle disputes on intellectual property rights. When it comes to patent, that is why we have a requirement of every invention. See, students, here when it comes to the right of protection, when we talk about protection of intellectual property, it is very difficult to protect intellectual property as compared to real property, because as I said that property has time boundation. Real property like house has a space, time also, but like intellectual property, they have no time dimensions, no space. They can spread all over the world. So identify them and you protect our rights is a very difficult task in case of intellectual property is concerned. Now, as I said, when it comes to patent, that is why we have a requirement of every invention to be expressed in writing, disclosed in a great detail, differentiating itself with every other invention that went before it, which is close to it or proximate to it, and then explaining the contribution made by the inventor. With regard to what has gone before, what has gone before is generally referred to be by a term called the prior art, and then demonstrating what is the inventive contribution that he made. The claims are actually for what the protection is granted. The protection in a patent is confined to what is mentioned in the claims and not what is mentioned in the descriptive part of the patent specifications. If you put everything in writing, there is a scrutiny that is done by the patent office. In India, it is done by the Indian Patent Office, and only when you pass the test that the Indian Patent Office will subject your written descriptions to will you be granted a patent, which will give you a title and a protection for a limited period of time, provided you keep it alive by paying the required fees. See, when you are going to file your patent, for that you need to pay a fees in that particular office, and it is also again and again renewed after paying such a fees. Then only it will be lived, otherwise it will be left. Now, we have discussed rights, we have discussed in property also. Now we are going to discuss what this intellectual means. The intellectual part of intellectual property rights, we refer to things that are coming out of our intellect. Intellect means our creation of mind, knowledge, understanding. By being intellectual, we refer to our ability to think and understand things. Sometimes things are complicated. So it is the ability to think and understand ideas, sometimes which some of those ideas could be complicated ideas. So an idea is something that comes out of a mental effort. We could also say that an idea is a product of careful thinking. See students, when for your knowledge sake, you all are aware of research and development. So idea is not an easy task to create an idea. It is a complicated thing which comes only by creative thinking. You may have heard of these kinds of stories where you find that a movie maker has spent 10-20 years in writing a script of a movie, and the movie is going to complete in so many years. So writing a movie, making a movie is a creative thinking. It needs lot of efforts. So by intellectual we mean, or we are looking at the mental effort or the creative effort which could if you by intellectual means the creation, the combination of mental and physical effort. We also distinguish intellectual as something those who are creating ideas, those who are putting so much mental effort are different than the general public. So we can say that they are intellectuals. This is what intellectual means. We certain times in general sense also say that what he is intellectual, they are intellectuals. So intellectual called creative people, creative thinking, mental effort. Now what are the characteristics of intellectual property? Now I want to introduce you some important characteristics of intellectual property. See, intellectual property rights generally protects applications of ideas. They do not protect ideas. In fact, ideas by themselves cannot be protected, but applications and expressions of ideas can be protected. See students, again, it is again very important that you or me or so many people have so many creative ideas, but until and unless we put that idea in writing, and not only in writing, we have to register it through so many legal aids or means, and when you got your right, then only your idea will be protected. Otherwise, it will be stolen by anyone, it can be misused by anyone, and you cannot do anything. That is the most important difference between the normal property like land and intellectual property. So it could be the same idea. Now the best instance would be, or one illustration would be the genre in literary work crime fiction. You all have seen so many crime novels where the same idea, it could be the same main character who solve these plots. Nevertheless, each idea is expressed in a different form, and because it is expressed in a different form, each idea as it is expressed in a different form can have a separate right. So you have seen, in simple terms, I want to convey you have seen so many films which are again and again repeated. The basic idea has changed, but the location is same. So again, presentation of a idea in a different manner is also called creativity. Now, ideas are, or intellectual property is also protected by law, means it is enforceable right. Means if you have registered your idea, it can provide you the right to exclude anyone, allow anyone to use or not to use. So the first thing that they are protected by law, that is the first thing, because there are could be very valuable information and idea which the law does not protect. But when we talk about intellectual property rights, we are talking about a specific right, be it a patent, be it copyright, be it a trademark, design, geographical indications. There are so many kinds of intellectual property rights which are available. We will discuss each one by one. The first thing, for something to qualify as an intellectual property right, it should be enforceable. It should be in the nature of a right. There should be an entitlement. Somebody can claim something based on it. And if there is a violation of that right, there should be a remedy also. Means if somebody has violated, trespassed in your right, you can, as per law, take action against the person who has misused it or stole your idea. Now, patents offer protection if there is infringement or violation of a patent. There is a remedy. You can stop the person from asking him not to do that thing, or you can claim that we call monetary compensation or damages. So certain times you ask for damages also. You can ask him to not to use it. You can ask in the court of law about the monetary damages also. Now, there it, as I said in starting also, that they are intangible, that they are different from normal property. These rights are intangible. You cannot touch and feel them, but they manifest in the end product in some way, and because they are intangible, they need to be described by some means. See, as I told you that these rights are intangible, so we need to describe them in detail. So the description part has led to various forms of recognizing the descriptive part. In a patent, it is described in writing by something called a patent specification. And this patent specification undergoes a process, what we call patent prosecution within the patent office, and it emanates as a patent right. This entire process, in a very simple language, we call it registration. As I use this word so many times, so registration means writing, prosecution, and grant. All these are combinedly called registration. The same is for design. Designs can be described and they can be registered. Trademarks can be described and then can be registered. Copyrights. So these are few things important things which we should take into account while dealing with the patents are concerned. Now, I just want to introduce you few, as considering the limit of time, I want to introduce you with few kinds of intellectual property rights available in India. And one of them is patent, trademark, geographical indications, license, copyright, etc. Now, first we are going to discuss about patent. Patent protection must be available for eligible inventions. See, there are two kinds of patent available in India or abroad also. One is product patent and another is process patent. Product patent means you have created some product and you are going to register the material used or the formula used in that product. This is called manufacturing part. Process means the way of making anything is called the process. So you can register a patent for process also or product also. So, and eligible inventions include both products and processes must be protected at least for 20 years. For example, if you have done anything good which can be registered for patent, so patent provides you a security of 20 years. Means up to 20 years, no one is going to use it without your permission. Now, patents grant exclusive right. They are conferred by the government. As I said, exclusively means it gives the ability to stop others, and the right pertains to making, selling, using, offering for sale, and importing. And the right exists for a time period which I said is 20 years from the date of application, after which it falls into the public domain. So whatever was covered by the subject matter of patent will then be free for everybody to use it. The duration of a patent was not 20 years in India. It used to be 14 years, and for pharmaceuticals in India, the term used to be up to 7 years. It was a flexible term. If it is used to be different for pharmaceutical, food and agriculture products, the term used to be even lesser. Now, copyrights. Most of us are aware of about the copyrights. Means if we write a book, song, or any literary, artistic work, soundtracks, videos, cinematography, computer programs, and whole lot of things are given copyright. The copyright gives the creator fixed number of years to print, to publish, to perform, to film, or to record literary, artistic, musical, or other cinematography works. The copyright is granted for the life copyright. The copyright holder has granted the copyright for his life plus 60 years after also. Means if you have, or any writer has a copyright of a book, means he has a copyright of that book for his life plus 60 years after life. Now we will discuss about design. It is again a kind of copyright, again a kind of intellectual property right. Designs are used to protect what can be distinguished by the eye. For instance, the law of designs is different from the law of patents, because designs are not used to protect something that is functional. Designs means artistic work. Designs are used to protect something that appeals to the eye, something that is visually appealing to the eye but does not have a function behind it. Design, again, it is an exclusive right. It is conferred by the government which means it involves registration and is granted for 15 years. See, students, designs are the outer, for example, a car has a specific design. So that design has to be protected and somebody has created that design. So that can also be protected by the... Hello? ये बेटा म्यूट करो अपने को, क्या नाम है इसका, बच्चों से.
Other participants, please mute yourself. Hello.
मैडम ये बच्चा कौन है, इसे रिमूव कर दो या तो सभी के में आ रही है.
Jyoti ma'am. Hello, Jyoti ma'am.
बंद है.
Control is in your hand, ma'am. Please mute all others.
Okay. Now I am giving the example of designs, like the design of a car, like the design of a mobile phone, or any kind of designs. They also can be protected by the government, Indian government law, up to 15 years. Now, trademarks. You have seen certain kinds of trademarks like Nike, like Mercedes-Benz logo, like the logo of IIMT University. So these are called trademarks. Trademarks are used to protect words, symbols that can be attributed to trade. In trademark, right is for you to ascribe a symbol or a set of words. Trademarks can be of a fixed term up to 10 years, but they can be renewed as long as the right holder places some of the trademarks that are in operation. Like the Coca-Cola mark are very old, close to 100 years or more. So there are no limit to this category of intellectual property, because their life is as long as the right holder wants to keep them alive. He just needs to pay money to the government as official fee, and he also needs to take action against people who may use it. Use is right. Now, geographical indication, as the word show use, that is related to geography, geography of particular area. So it is again a kind of intellectual property which is a lot of, which has a lot of importance for Indian people, because you all have heard in recent past about the patenting of haldi, neem, or certain kinds of Ayurveda material, which can be protected under this intellectual property. So geographical indications can be used to indicate the origin of a certain goods, means from where that particular good is originated. For example, Darjeeling tea. Darjeeling tea shows that that particular tea is created from Darjeeling. So there are certain kinds of geographical indications. Basmati rice shows the rice which is produced in a certain area is only called basmati rice. Now, using this indication when the product was made elsewhere or when it does not have the usual characteristics can mislead consumers and can lead to unfair practices. That's why these lights are provided. Now, trade secrets. This is the last but not the least. Intellectual property right is also available to protect the trade secrets. Many times our secrets are informations relating to trade which the owner of the information wants to keep it a secret. Test data submitted to governments in order to obtain marketing approval for new pharmaceutical or agricultural chemicals must also be protected against unfair commercial use and disclosure. And many times it happens, we file certain applications in government office to take the approval of pharmaceutical production. So in that case, that trade secret may not be revealed to someone else, is also a kind of intellectual property rights which are provided to the individuals, so that by through which we can protect the our trade secrets also. So students, I hope you have got this section right. Nidhi ma'am.
Yes, sir. Yes, sir.
Over from my side. If anybody has any question, feel free to ask. Thank you.
Thank you so much, sir. It was a very informative session. Participants, if you have any question, any query, you can ask to Dr. Tushar, sir. Sir, I found it very informative, and I would like to thank you a lot, sir, for giving your precious time. Thanks a lot, sir.
Thank you, ma'am.
Thank
Hello.
you. Yes. Hello. Yes.
Hello.
Yes, you are audible.
Yes, ma'am. Ma'am, I would like to ask.
Yes, yes, please ask.
Ma'am, I would like to ask the meaning of trespass.
I think Shruti. Who is asking?
My meaning of trespass.
Arjun sir, are you here?
Meaning
Hello?
of trespass in IPR.
I think Arjun sir is not here. I'm requesting him. Just wait a minute. Arjun sir, are you here? Arjun sir?
Wait, he's connecting.
I think that he is not able to join again. Maybe some net correction. So I would like to end this session now. I will request you all to please join at 2 p.m. as there is a very reputed and honorable speaker of the day for the second session, Professor Alin Saxena sir. So I would request all of you to please join at 2 p.m. on the same Zoom link for this for the next session. Thank you all of you.